You can take it away.
Thank you, Anthony. I'm really pleased to be here. I'm going to add to your burdens by uh, requesting that you like cough loudly as at like 44 minutes or do something to make me aware that I need to wind down. And I should say that we always federal U.S. federal employees and contractors always begin with a disclaimer. In light of recent developments, this is a particularly emphatic disclaimer that the views expressed in this presentation are solely my own. They don't reflect the positions of the U.S. federal government, NIH, or my department, and I may be the only one who holds them. And I'm not even sure about that, as I was reminded. So, what got me thinking about parental liability for prenatal negligence was in part it began with a project in our department that was looking at the dramatic increase in um, prenatal interventions or promised prenatal interventions, not just surgery for spina bifida, which has been around a long time, but the prospect of neural connectivity for Down syndrome using FDA approved drugs. This that would increase cognitive function and allow ambivalent parents or encourage ambivalent parents to continue uh, their pregnancies. So, but what I saw coming was the prospect of a huge battery of diagnostic tests and possible procedures that pregnant women would, or pregnant people would be facing in the not too distant future. And they'd have a lot more to expect when they were expecting than they do now, which is already quite a bit. So at the same time, I was sort of struck by that. I uh, was keenly interested in um, an article that came out a few years ago arguing that uh, pregnant people, have no duties to the future child beyond ensuring them a life worth living. A view that takes off from Thompson's view that you're a good Samaritan if you know, a very good Samaritan if you agree to carry this strange creature to term, and anything else you do, uh, you know, beyond bringing out a viable fetus without a totally awful condition that's going to render their life a nightmare. Anything else you do is supererogatory, is just, praiseworthy. And I was convinced that was wrong, but in trying to address that, I came to a view that it had more truth than I expected, although only significantly qualified. But in a way, this sort of philosophical argument and these biomedical trends are pulling in the opposite direction. The one sort of threatening a massive increase in gestational responsibilities, the other is denying that there are many or any significant ones. So this was an intriguing area for me. Um, I'm going to be reading through my slides. I'm covering a lot of territory, and you may lose the plot. I sometimes do. I'm pleased if you want me to clarify something as I go along, just put something in chat like a big question mark, and then I think Anthony can kind of let me know that I need to pause for a minute. Um, okay, and so with that, let me start. Um, the background is that most critics of criminal and civil liability for prenatal harm have been willing to assume, for the sake of argument, that the pregnant person has special duties of gestational care for the child she carries to term. duties that require more than she would owe a stranger, she was willing to keep alive for 9 months. That's meant to echo Thompson's infamous violin analogy, which I will return to. These authors offer powerful moral, legal, and policy reasons for not enforcing those special duties through the criminal or civil law. And by and large, I'm not going to be disputing those arguments. Recently, though, the assumption of special gestational duties has been questioned by some philosophers, notably Jessica Flanagan. Taking off from Thompson's violin analogy, they argue that the pregnant person who chooses to carry the fetus to term has only the minimal duty to not deny the child the life worth living. If these philosophers are correct, there's no need to invoke privacy, autonomy, or gender equality against the enforcement of special duties of gestational care. The pregnant person has no such duties. Now, if there were no such pre-existing duties, the state could still impose legal duties of care to protect the health of future children, but the burden of justification would be much greater because these were not would be laws that would not be enforcing pre-existing moral duties. So it would be a much harder case to make. And I'll maintain that these philosophers, they're Flanagan, uh, are partly correct. Um, Pregnant people can carry a fetus to term without acquiring special duties to care. And I think this possibility has been obscured by the widely shared assumption that pregnant people who continue gestation intend to parent the future child, or in some cases are acting for those who do. They're arranging adoptions and then starting to act as agents for the adoptive parents. Now, but that assumption may be mistaken, and as it may be in increasing the ranks of well, I'll say that for later. But even when it is correct, the assumption that the pregnant person who declines to abort or can't abort is planning to parent the child, the special duties she acquires remain conditional until the child is born or is no longer permissible to abort. Now I'm going to drop that second part because I don't want to get into debate about whether there's any point before birth when it's permissible to abort. I just want to make clear that when I talk about permissible to abort, I mean morally permissible to abort. There are at least 20 states in the United States when it is not legally permissible to abort in most circumstances, but that's not what I want to focus on. I want to focus on the sort of moral duties, if any, that pregnant people have toward future children. Okay, so I think that given that these are conditional moral duties, um, conditional on bringing the child to term, I think that measures to prevent prenatal injury, which have been decried for other reasons, are unjustified as well as counterproductive. The pregnant person does not have only has a conditional duty, and they, at least in most jurisdictions, still has the authority to decide whether that condition is satisfied. So intervention when that duty is still conditional is really hard to justify. Um, and finally, in this background and overview, one of the strongest arguments made against the postnatal enforcement of special duties by Rosamund Scott also raises questions about the character of any underlying moral duties. Scott offers different objections to offers different objections to different areas of prenatal conduct. She claims that it is difficult to adjudicate liability for harmful treatment refusals by pregnant people, since it's difficult to establish a standard of gestational care. She claims that it's unfair to impose liability for harmful prenatal conduct that would otherwise be strictly self-regarding. So she treats these two areas, a sort of response to medical interventions and any restrictions on everyday conduct, as two separate domains, and she has different objections for um, legal enforcement in both domains. But I'll argue that Scott's fairness objections overstated, but that her concern about gestational standards of care has considerable force for risky prenatal conduct as well as for treatment refusals, the area to which she applies it. Okay, first a preliminary point. The moral status of the fetus has little relevance to gestational duties of care. Any such duty is owed to a born child. Such a duty can be breached by, and here I say, non-identity dependent actions that occur before the child's birth. Now, the reason for that parenthetical is that as fascinating as I find non-identity issues, they're issues for another day. I am concerned here not with interventions that might alter the identity of the future child, but with interventions that will leave the future child's identity unchanged, although may have a profound effect on their lives. And the classic example is Joel Feinberg's bomber who places a bomb in a schoolhouse closet years before it's occupied by the students who are then injured by the explosion. And clearly, at the time he planted the bomb, those children, they, there were no uh, there was no one with moral status who was going to be harmed by that, who at that time were harmed. I mean, these children weren't even conceived yet, the way he frames the case. But of course, he's liable for harming the children who later come into existence, go to the school, and are harmed. So I don't think that's an interesting issue anymore. So I wanted to set it aside. And then the permissibility of abortion itself need not rest on the moral status of the fetus. And certainly in the debate that I'm tapping into here on the gestational duties of care, it's been assumed, uh, for the sake of argument, that the fetus is a person, just a person who can be regarded as a stranger to the pregnant person. Um, One philosopher, Elizabeth Harman, has even gone so far as to argue that the fetus retroactively acquires that should be moral status, if and only if it becomes conscious at some time at a later point. So that means that abortion not only prevents a later complaint, it ensures that whatever injury was inflicted prior to abortion was inflicted on a being with no moral status. But that's a strange and interesting view. Unless the uh, pregnant person has decided to parent the child, her fetal care duties are minimal. At least that's what I'm claiming. If the pregnant person carries the fetus to term with no intention to parent and no agreement to gestate for someone else, she has only minimal duties of care. I will call such a pregnant person a mere carrier. Um, Her only duties are negative ones. By the way, what I've been doing, I do believe it's appropriate to talk about pregnant people, but I use the feminine pronoun and I talk about intending mothers. So I'm sort of adopting a semantic compromise that probably is going to satisfy anyone, but that's where I am. Anyway, her only duties are negative ones, not to deprive the future child of a life worth living, and also this is just not something I'm going to pursue here, but not to harm it maliciously or opportunistically. I think that if you assume that a fetus is a person with rights, then even though it may have no right to be carried to term, no right to demand anything but a life worth living if it is, it still has a right not to be exploited or not to be maliciously injured. But that's an aside. Okay, so the pregnant person's conduct is not the mere carrier's conduct is not even limited by a duty of easy rescue, a duty which only a few jurisdictions recognize in the first place, but a lot of moral philosophers do. Because the cumulative burdens of gestation far exceed any plausible limit on that duty, taking any additional burden is supererogatory for a mere carrier, even if that burden consists of taking a pill or getting a painless injection. So, um, what I mean, I don't know if this proof of concept is needed, but I just have the next three slides present a case that I used in a recent article to talk about, rather than talking in abstract terms about a mere carrier, I wanted to present a case. And so you bear with me. A childless by choice woman experiences a contraceptive failure. She had taken precautions, not only because she does not want to parent a child, but also because she has reservations about abortion. She feels no attachment to the fetus she carries, however, but is reluctant to pursue adoption, which would require her to assume responsibility for a fetus for whom she lacks any maternal feelings. Once the child is born, she plans to drop it off in her local safe harbor facility, which has excellent placement services. So she has every reason to believe that the child she bears will go on to have a life worth living, maybe a hard life, maybe a challenging life, but not a truly awful life. Meanwhile, the woman is getting ready for a once in a lifetime trip to view a melting Antarctic glacier. At an OBGYN visit, a few days before departure, the ultrasound shows a spinal curvature that's likely to cause frequent discomfort and reduced mobility for the future child. Um, while there is no effective postnasal treatment, safe prenatal surgery can correct the curvature, a procedure requiring only one night in the hospital and a week of bed rest. Unfortunately, she would have to cancel her trip. That's what I'm calling the carrier's conundrum. The woman believes that the child would be significantly better off getting the surgery and that no responsible mother, and I put that in quotes, would decline it. But she does not regard herself as a mother or a prospective mother. She also believes that the child is very likely to have a good life without the surgery. Its condition will not be a barrier to adoption by a loving family or to many rewarding activities and careers. So, unwilling to give up a once in a lifetime trip, she declines the surgery. Now, I happen to think that what she did was perfectly reasonable, that the child, even if it learned all these circumstances, would have no moral, um, uh, let alone legal grounds for complaint. I do think that child would certainly be entitled to feel disappointment that she had gone the extra mile. But I think that under the circumstances as described, the child wouldn't have a moral claim. But again, we're talking about a small class case, well, a small group of pregnant people who do carry the fetus to term, but don't intend to parent. Now, in at least 20 US states, that class may be growing significantly once, you know, abortion becomes almost impossible to obtain. Um, but I mean, there are such cases now. The case I just described is hardly fanciful, and there are going to be more such cases. But even so, I think it's safe to assume that most um, pregnant people, particularly in jurisdictions where there's safe and legal abortion, who carry the fetus to term, either intend to parent the child or put it up for adoption or arrange an adoption. But I'm going to leave off that second possibility just for simplicity's sake. Where the person's acting as or the pregnant person's acting as the agent of another intending parent. Okay. By making a decision to parent the future child, then carrying the fetus to term, the pregnant person acquires more stringent duties of care. I will refer to a pregnant person who's made that decision as an intending mother. That decision should not be seen as an isolated act of will, just sort of suddenly person, blinks and says, I'm going to have a child, but as part of a planning process. This is the way Michael Bratman understands intention, guiding prenatal conduct. I mean, it's a very familiar idea. A pregnant person decides to have a child. She informs family and friends. She buys diapers and other infant care supplies. She seeks maternity leave. So this is not all in the head. Um, but the duties arising from that decision and their breach remain conditional until the pregnant person has carried the fetus to term or abortion has become morally impermissible. Okay, so this is sort of amplifying a point I made earlier. The moral permissibility of abortion precludes coercion regardless of the pregnant person's parental intentions, up to the point, if any, when the pregnant person is no longer morally permitted to abort. Coercive measures to prevent harm to the future child are not only counterproductive, but extremely hard to justify. Until that point, any minimal or more than minimal duty she has to the future child is conditional, and as conditional is not yet subject to enforcement. The pregnant person may prevent any conditionally negligent injury. I'm saying conditionally negligent because negligence implies a standard of care, which is only conditionally applicable, as presupposes a standard of care. Um, to the fetus from becoming a tortious wrong, she can prevent that by aborting, although it would be better for the child not to abort. And that was called the paradox of abortion and prenatal injury by Jeff McMahon. It's something that a number of philosophers have written about, the idea that, uh, a pregnant person, say, who has injured a fetus and doesn't want to bear the responsibility of having caused harm to an actual child, um, is free morally to abort, although it would be clearly in the future child's interest, unless the injury is really, really severe, profound, for her not to abort and to bear that responsibility. But that's again something I can't pursue here. Um, if the pregnant person chooses not to abort, she may, and that the may is intended, may be liable to the child for a breach of gestational duties. When the child is born, not sooner, any breach of prenatal duties becomes final. A mere carrier has not breached any conditional duty if she leaves the child with a life worth living. I'm sort of repeating myself here. But if the pregnant person has decided to parent the child, she may be, at some point during pregnancy, she may be liable for injuries that result from a breach of the gestational duties she had assumed and that have now become unconditional. Now, that's not to say that it would be just fine to allow, a lawsuit for negligent prenatal conduct by the child. I mean, there are other moral considerations that weigh heavily against recognition, alone enforcement of such a duty. Okay. Um, and this is a point that I think also has not been denied, but also not been adequately recognized. Non-gestational intending parents also have more than minimal duties of care to the future child, to donate blood, to avoid smoking near the PP, and there are many other examples, especially given the burgeoning literature on the epigenetic effects that a partner can have on the development of the fetus, the child, and future generations. Those duties are conditional because they can only be breached if the fetus is brought to term. Now, unlike the pregnant person, intending co-parents don't get to decide if that condition is satisfied. At least they shouldn't get to decide if that condition is satisfied. This difference, however, should not insulate them for liability for postnatal harm caused by a prenatal breach of those duties. Um, and moreover, the civil enforcement of those duties would be less intrusive and burdensome for an intending co-parent than it would be for a pregnant person. I mean, although their conduct might have been otherwise self-regarding, they are still, the enforcement still is having far less of a chilling effect because their conduct starts being so much less constrained than that of a pregnant person. Um, Now, returning to Scott, whose writing on this topic really influenced me, she offers two challenges to the enforcement of the duty of gestational care. First is the difficulty of establishing a standard of gestational care for intending parents. And the second is the unfair burden on an intending mother of satisfying such a standard. And Scott sees one, the difficulty of establishing a standard of care, as a problem for positive duties to accept medical treatment. She sees, too, the unfairness of the burden placed on pregnant people as a problem for negative duties to avoid conduct that would otherwise be self-regarding. So two arguments for two different domains of conduct, or two objections for two different domains. But I'll argue that one applies to both areas. The um, standard of care challenge applies to both areas of prenatal conduct, and that it is a more plausible objection than the unfairness one to recognize and let alone enforcing a special duty of care in either area. Scott argues that the values and circumstances of pregnant people are so diverse that it's impossible to establish a standard of care for the medical and surgical interventions that a reasonable pregnant person would accept to protect the health of a future child. I think that's a plausible argument, but it's plausible both for mere carriers and intending mothers. Now, for mere carriers, a carrier's only gestational duty, once again, um, uh, is not to deny the future child a life worth living. This duty might require her to accept minimally burdensome treatment, like a shot or a pill, but only if that treatment was first likely to cure or mitigate a condition that, second, was likely to leave the child with an intolerable life, a life not worth living. But it's going to be rare that one and two are both satisfied. There's likely to be significant variability in the impact of most serious conditions that are prenatally diagnosable. So it's very hard to say that they would lead to an intolerable life in any given case. And there is likely to be considerable disagreement about how bad a life must be to be worth not living. Um, Different kinds of disagreement, but both quite sharp. The treatment for such conditions is also likely to be burdensome and intrusive for the pregnant person and of uncertain efficacy. So, um, there would likely be considerable disagreement on how much of a burden a reasonable carrier would assume for the uncertain prospect of preventing the future child from having an intolerable life. Remember, this is a person who agreed to sort of to carry uh, the creature she regards as a stranger to term, but has assumed no other responsibilities for it, does not feel like a parent, has not assumed the role of a prospective parent. In cases where there is no effective treatment for a condition likely to leave a child with an intolerable life, it would be debatable whether a carrier with no responsibility for the condition has a duty to terminate the pregnancy. I mean, that's a terribly difficult issue. I mean, I can see myself, I would be torn by that. I mean, the idea that someone is carrying a fetus with a condition so dreadful that it's almost certain to cause it a brief nasty, brutal, painful life. The idea that they're morally required to abort has some appeal, but I still find it difficult to embrace anyway. But um, okay, so right now, there is a significant barrier to any civil liability for post natal harm that I wanted to point out. If I were interested in quick closure, which I am obviously not, I could just stop here. With this slide, although most pregnant people who decline to abort or arrange adoptions intend to parent the child, some and a growing number in the United States don't. If I'm correct that those who don't have only a minimal duty not to deny the future child a life worth living, they would face liability only for wrongful life, a cause of action few jurisdictions recognize. I don't know if I believe that France did at some point. I don't know if there are any Canadian jurisdictions that do. I don't think any in the United States do at present, but I could be wrong. To impose further liability, it would be necessary to show that the parent had been intending to raise the child at the time she caused prenatal injury. While the kind of intentions that would make the person liable would typically be reflected in her conduct, like buying diapers or announcing a family addition, it would be highly intrusive to establish that she had such intentions at the time the injury occurred. At least I would, balk at supporting a legal action in which that was a critical element of the plaintiff's case. Um, a standard of care for intending mothers. It would be no less difficult to establish a standard of care for pregnant people who have decided to parent the future child. Scott points out the lack of consensus about the medical treatment that a pregnant person would accept. And this is a quote from her. People think it reasonable to assume quite different levels of physical pain, burden, and risk for themselves. How can we say of a pregnant woman who refuses a cesarean in order to avoid eternal damnation, or because she would rather die than have such surgery again, um, uh, or because it carries a risk of death 4 times higher than natural delivery, that she is falling below uh, the standard of care that a pregnant woman owes her fetus. And I think that that's somewhat rhetorical question is very well taken. Um, and I think that actually the sort of the uncertainty and the difficulty of establishing a standard are going to become even more difficult because adequate um, gestational care is going to become a rapidly moving target. Advances in fetal medicine are likely to intensify uncertainty and disagreement about the appropriate standard of gestational care. Pregnant people will have to decide about a growing array, and this is a quote from an earlier piece I wrote for Hastings Center report. Pregnant people will have to decide about a growing array of diagnostic, preventative, and therapeutic measures to improve the odds of giving birth to a healthy baby. Some measures, like FDA-approved drugs with few side effects, will impose only slight risks and burdens. Others would impose serious risks and substantial burdens. So I just imagine, that the prospect of um, reaching consensus on what you know uh, reasonable pregnant a reasonable intending mother would do are daunting. Um, the Anyway, the Scott objects to imposing civil liability for maternal she has a different objection. I mean, related, but I think quite different. Scott objects to imposing civil liability for maternal activities um, that should be prenatal injury because of the social context of pregnancy. For a pregnant person to be liable to her unborn child when she solo cycles, sails, or skates without third parties' presence would be unjust because she can never be without the unborn child. It is hard, we might say unjust, to defend the idea that a woman should be legally compelled to consider the impact of all their actions on the subsequent born child. And I think this objection is overstated. Scott's surely correct that it would be unfair to require an intending mother to consider the impact of all her actions on the subsequently born child. That would, you know, be paralyzing. Um, Such exhaustive and exhausting vigilance would be clearly be an unacceptably high price to pay for protecting the health of the future child. But that's sort of a straw standard. Or maybe it's not. And I'm sure there are, you know, corners of the social media where no less would be demanded. But um, Scott needs to argue that it would be unfair to impose even a more relaxed, flexible standard of gestational care. And that's, remember, on pregnant people who intend to become parents. A difficult argument to make. A duty of gestational care that only required the intending mother to avoid activities with a high risk of serious injury to the future child, and only when she could do so without any significant physical or mental burden, would hardly be unfairly constricted. Indeed, a lot of people would probably find it too lax. And it's also, although the burden imposed on the pregnant woman is the heaviest, I don't think it's quite, I don't know if you can be quite as unique. It's not a unique burden. As I've suggested, intending co parents also have constraining prenatal duties. While they have a more flexible social context, since they can, I'm quoting Scott here, be without the unborn child, their proximity to the pregnant person, the fetus, subject them to restrictions on otherwise self regarding conduct. Bowden argues that the pervasive, Catherine Bowden, in a fairly recent article, argues that the pervasive impact of intending fathers on fetal development provides grounds for granting them the same exemption from civil liability for postnatal harm that UK law grants mothers. But I think, you know, the reverse can be just as plausibly argued that setting aside policy concerns, which is quite a lot to set aside, an equally plausible case could be made for not exempting either fathers or mothers from uh, reasonable care measures. But while it may not be unfair to treat intending mothers as assuming some additional burdens of care, it may be extremely difficult to reach a consensus on the scope and stringency of those duties. Scott raises the concern about an expected standard of care for medical treatment, but it applies with as much force to gestational conduct by the intending mother. If people think it reasonable to assume quite different levels of physical pain, burden, and risk for themselves to protect the future child, they also think it reasonable to assume quite different levels of caution in undertaking their daily activities. And they accept quite different trade offs between child protection and their other commitments. So I think the most powerful objection that Scott raises applies not only to refusal of medical treatment, but to risky everyday conduct. And I'm only got about 5 minutes more, if that's okay. So the this uh, it's instructive to contrast a gestational standard of care with conventional, evolving, but still widely recognized minimal standard of care for postnatal parental conduct. Several factors, especially the private character of gestation, make it even harder to establish a reasonable standard of care. Um, in part because the social context of parenting is less constrained than that of pregnancy, um, and more accessible to uh, third parties, trade-offs between children's and parents' interests, may be more accessible and easier to evaluate by public standards. This isn't to say that, you know, it's easy to find acceptable standards of care for reasonable parents, because there'll always be fierce debates about the best ways to raise children. But that need not preclude a consensus on what counts as minimally good parenting. And I think my point is that I think it's much harder to reach consensus on what counts as minimally good proto-parenting or intending parenting or gestational care. Um, the difficulties in establishing a standard of care raise doubts that gestational care duties can be determinate, let alone enforceable, except in extreme cases. But this doesn't mean intending parents lack such duties. I don't want to go as far, I don't want to get back to the position I rejected, that really there are no duties of gestational care except assuring a life worth living. We could see gestational duties as somewhat akin to imperfect duties, giving the intended parents wide discretion in protecting the health of their future children. Um, Scott suggests that the character of gestational duties, she suggests it, she's not really focusing on it, in stating that a pregnant person who refuses to suspend activities that could seriously harm the future child may have a misplaced sense of the importance of her activity compared with her child to be. And she admits that this notion requires further fleshing out. And just to flesh it out a tiny bit, I think it can be plausibly understood as a duty to give due weight to the interests of the future child in deciding on the sacrifices that an intending parent is willing to make to protect its health, the health of the future child. An intending parent who gives no more weight to those interests than he would to those of a future stranger violates that duty. But I think it's an unenforceable duty. The intending parent himself may have grounds to believe that he violated the duty of gestational care by failing to give due weight to the interests of his future child. He's privy to his own deliberations. He knows how much he values competing commitments. He can make that kind of judgment, and certainly may have grounds for self-reproach. And his partner and eventually the child may also know enough about that parent to criticize him for violating a duty of prenatal care. But the kind of evidence they would have to have for that violation would usually require far too much personal information to establish civil liability. I mean, it would require knowing so much about the person, what values they placed on other things, how they resolved other conflicts in other contexts, that I just think would be a non-starter as any kind of a legal case. Now, there may be, and this is sort of the elephant in the room for me, is extreme cases. And I haven't said much about them, but I just can't ignore them. There may well be cases where it's clear that the intending parents gave little or no weight to the interests of the future child in deciding to act in ways that causes serious harm. Now, I think that's really hard to ascertain. I mean, the cases which is clear may be fewer than and far, maybe few and far between. For example, a pregnant woman who's addicted to a toxic substance may try really hard to control her addiction, not succeed only partially, and end up causing serious injury to her child, but having given very heavy weight to the child's interest. So I think, it's very easy to reach the conclusion that a pregnant person gave literal no weight when that's not the case. Well, but in such cases, if there really are cases absolutely clear cut, just pregnant person recklessly partying nonstop for 9 or 10 months. I mean, that's somewhat fanciful, but in such cases, there may be even then, there may be compelling policy reasons against civil liability. It would be counterproductive, and it would likely have a discriminatory impact on people too poor, disadvantaged, or stigmatized to get really good prenatal care and to live comfortably in ways that protected their future child. So I'm going to end here. I have a little coda, I called it, about the one other case in which, besides pregnant people, in which the social context is really constraining, and that's conjoined twins, which I have had in somewhat independent interest, more as a disability scholar than for a long time. But since you should have copies of the PowerPoint, you might want to look at that. I really think it's intriguing, and the bottom line is I don't think there's a very different reason why I don't think we should expect to find standards of care for conjoined twins, partly because most of them are now not only separable but separated very early on, but also because there's still so few conjoined twins that the kind of experimentation and debate that are needed to develop a widely accepted standard of care just aren't going to happen. There just aren't the numbers. So I'll conclude with that, and then I guess we still have some time for questions.
Yeah, for sure. Thanks, David,
And
for that.
I'd like to get out of here if I could. Yes, I'm going to stop sharing my screen.
Right.
Folks who have questions about specific things, if you can refer, I've got a printout here. I mean, rather than obs, obscure the screen again, it would be good if you could just refer to that. But I'm open to any and all questions. So
Sure. So thanks, David. Yeah, and I'll take the cue on questions. So you can either use the raise hand function over Zoom to get on the queue, or you can go ahead and type a question into the chat. So um, a lot of very interesting both legal and moral dimensions, I think, to the talk. So I do have a lot of questions of my own, but before doing that, I'll
I should just say that
invite.
you may have had trouble following the plot, and don't be afraid to ask if you just, wondered about where you lost it. I mean, this was a long presentation, very wordy PowerPoint, so, it's not too late for clarificatory questions as well as critical ones.
Okay, go ahead, Stephen.
David, thanks very much for the talk, and you're not doing it justice to say that it was wordy and complicated. I think you did a good job actually leading us through some really tricky material. It's not my primary area. I have this kind of core sense, I guess, that Canadian law, certainly on the tort side, is just much less nuanced than the American position, in that I think we just start from the idea that there just is no duty between I'll just call it a mother and the unborn child. And we don't, and this is what I thought was the most interesting part for me of your talk, we therefore don't get into anything like the kind of granularity of the different sorts of pregnant people. And in other words, ones that are intending to keep the child, ones that are intending to give it up for adoption to somebody who they might know, ones that want nothing to do with it sort of once they're done. So I was quite fascinated by the idea that the duty, and therefore ultimately the standard on them, could differ at that level of granularity.
Well, let me ask you a question, because this is striking difference. You mean you don't have Canadian jurisdictions where the law enforcement have imprisoned pregnant people who are ingesting dangerous drugs?
No, so that's it. So that I'm trying to stay away from that question. We have some law about that too, but I'm more focused on just the the duty of care, the private law duty of care, as to whether the subsequently born child could sue the mother for her conduct during the course of the pregnancy. And my sense is we've got some cases, and to the extent we have cases, they just say no. They just say in a very broad brush way, there's no duty on the mother to the unborn. I'm open to be corrected. That I know there are some experts on the call who probably know the Canadian law much better. So again, the part that fascinates me is this greater level of granulation between different types of pregnant person, and therefore the knock-on different types of duties and standards that they might owe. I was wondering, and I don't want to divert you, but I was wondering if you could say a little bit more about why you think a mere carrier should be segregated off and owe such a lesser level of duty from, say, an intended parent.
Well, the argument is that let's say, well, let's take a much simpler case. You become accidentally a woman in what's a state with in Florida, say, which has a 6-week fairly comprehensive ban on abortion, becomes pregnant despite taking enormous precautions, does not want a child, but faces draconian penalties. No doctor in the state is going to get near her to perform an abortion. She lacks the means to travel to a more permissive or liberal state. She's carrying, she can't abort. She is carrying a fetus to term. And I don't think that the fact that she's biologically responsible for the existence of that being and for the future child give her, I mean, there are those who would argue. I mean, I imagine, I didn't mean to marginalize religious views that would say, look, that just in that biological role engenders parental like responsibilities. I mean, my lame defense is that the community I'm arguing with and among does not accept that. And a little more robust defense would be I don't see any persuasive public reason arguments why that should be so. I mean, I actually Reuben Brandt, who writes very interesting stuff about reproductive ethics at UCLA, talks about procurators having some direct duties that would require more than simply not denying a child a life worth living. But those are very modest additional duties, not the kind that would that are anything like the sort of gestational precursor to parental duties. So I guess look, and there's a shelf's worth of literature criticizing and defending Judith Thompson's original analogy between a sort of accidentally pregnant person and a kidnapped person who finds himself hooked to a violinist who can only survive for if her blood is regularly transfused to him for 9 months. And I mean, her analogy has been qualified. It's been very ably defended in the whole book by David Boonin. But I mean, the general sort of direction of the argument is to say, look, even if the fetus is a person, unless the role of parent is voluntarily assumed during gestation, where does the duty to do more than leave the child with a life worth living come from. And there may be intuitively powerful sense that there's got to be some duty, but I just don't, I've not found a convincing answer. I mean, so I don't want to get too sidetracked. I mean, it's a very important point, but
Maybe I'll interject with a question, David. So maybe it's because it is sort of on a point that Stephen raises, but I wonder whether you think that, like, so clearly the distinction between mere carriers and intending mothers has some moral significance. I wonder whether you think anything controls that choice ex ante, whether that is a kind of morality-free zone or not, because because of the of how the choice might attract different duties or different standards of care. I'm just curious about that. So, like, I guess on the one hand, it's easy to see it as like an intensely private and kind of issue shielded from moral scrutiny. I'm not sure though. I think that you can imagine a case where a pregnant person becomes pregnant with a person of a different race or a certain race and believes that the race of the child is a reason to be either a mere carrier or to intend to parent the child. I feel like that decision would be subject to moral scrutiny more if in some way and may have an impact on the kinds of duties that so it might turn out that if that's the case, then morally speaking, the kind of different duties and standards of care that attend an intending mother as compared to a mere carrier might actually have a moral valence ex ante. But I'm just curious what you think about that.
well, let me make, I mean, I didn't want to discuss adoption because there was a lot, yeah, there were too many, or that sort of would have been made it too many moving parts to talk. But let's say, I mean, that's a nice case. So say a woman has a relationship with someone of a different race, ethnicity, background. The relationship ends permanently. Perhaps the person dies, so there's no chance of, and the pregnant person just feels very ill-equipped to raise a child with that genetic background and with say, a large family from that background. So I think at that point, I certainly don't want to wade into whether the issue, whether she would have any duty or strong moral reason to offer adoption rather than raising the child. But I do think that she could it would certainly be, I think she'd have the moral option of saying, look, I mean, I think it would be perfectly reasonable under some circumstances for her to say, look, I am not the right person to mother this child. But in that case, I mean, if she sort of then contacted the family and said, "Look, I really think this, well, let's work on adopting this child," she would then be at least starting a process in which she would become the agent for some principal or a proxy for someone who would become an intending parent, and then so she would have. So I mean, it gets complicated. She wouldn't directly have stronger duties of care, but she would, let's say, the family of the deceased partner lines up and adopt, and an aunt and uncle or something want to adopt. At that point, whether formally or not, that she's acting on their behalf. And I mean, there are difficult questions like whether, she what she owes them. I mean, that's a complicated thing. But to the extent she's acting on their behalf, she will owe a higher level of care to the fetus than she would than if she just said, "Look, this child is from a different race or ethnic background. The partner I was going to raise it with is dead and gone. I just can't, I don't feel like I have any connection whatsoever to this child. I'll drop it off in a safe harbor when it's born." I think in the first case, there are significant, the person assumes significant responsibilities more complicated than those in a standard case where the person intends to become become the parent of the child herself, more complicated in part because she has duties to third parties too, and the relationship between those duties and the duties to the fetus are complicated. But I don't know. I'm not answering your question. Just
No, I think it makes sense. Like, so it seems to me then that uh, where whereas it might be difficult to uh, identify a duty one way or the other. I could see how that there are moral reasons that can go one way or another. Um,
I'm quite clear that I don't think, one of the very good reasons for opposing civil liability is precisely because the first, to have a standard of care beyond a life worth living, you would need to establish something about the intentions and plans of the pregnant person and partner at the time that the injury occurred. And that's just, the idea that that would be the first thing you had to show in a lawsuit just would mean raising not only intimate details, but you know, there'd be all sorts of complications. What if I mean, very often people are ambivalent about whether they want to become parents. They may buy diapers because they see them on sale at Costco or Walmart. I don't know if you have Costco's and Walmarts, but say, well, just in case I decide to become pregnant, but I really haven't made up my mind. And so, I just, and then they do something foolish, go on a bender, and the child is gonna, the future child ends up having some significant permanent injury. I mean, do you want to be litigating whether at that point she was too ambivalent to afford me intention? I mean, I just don't see this being the sorts of thing courts should be adjudicating.
yeah, and I do have another question, but I'll let Stephen come back in. And then I think there was a couple of questions in the chat about Canadian law, but go ahead, Steve.
Yeah, thanks. So just two quick things. So, and again, unless I'm wrong, like I don't even think Canadian law imposes this minimal life worth living standard, right? Like I think it just says flat out no duty. So I find even that gradation interesting.
So, well, I mean, so in other words, let's say a pregnant person in Canada just had a vicious, acrimonious falling out with her partner, and she just deliberately ingested tetragenic substances, toxic. I mean, this is a horror. I'm not case, and deliberately gave birth to a child that just anyone would say this was a life not worth living. Just that child's estate could not. I mean,
So I think as a matter of current law that I could point to, I can't point to anything that right. I think your example is sufficiently graphic that it strikes me as easy for a court to adopt that, right? So in other words, that's why I find this interesting, right? Is our case law is so sufficiently sort of not granular that
oh,
we've just treated this as a binary duty or no duty. We've said no duty,
yeah,
and we haven't even asked the kind of horrible question you're asking. I suspect if we asked it, we'd get the
but
answer you're advocating.
historically, I mean, that's been the case everywhere. When people didn't know anything about pregnancy, I mean, they had no idea about the effects of alcohol. I mean, they might have realized that, say, stomping on a pregnant person could kill or serious injury. Beyond that, it was opaque. I mean, the policy, I think, in English law was, no duties whatsoever. And so that is the baseline from which we're going. So it doesn't surprise me. It's just, and of course, a lot of jurisdictions resist the idea of a suit for wrongful life, despite the horrific conduct that I was sort of trying to conjure up. The idea is, do you really want the courts to determine what a life not worth living is? I mean, even in you can hypothetical case where it seems obvious, but just that would be such a grim determination. Again, I mean, I think 30, 40 years ago, various jurisdictions experimented with wrongful life suits and most abandoned them. But I should probably move on.
I just want to address the points in the before going to Kenneth's next. Want to address the points made in the by Barbara in the chat, and maybe just add on to them too, because there are two main Supreme Court of Canada cases that address this kind of issue, saying about prenatal negligence on the part of parents, and they seem to be based, I think, on two rationales. One of them being that, as a matter of private law and like child protection issues and family law, like the fetus is not a legal person who can be understood to be in need of protection. This is the Winnipeg Child Services case called. Another
Yeah,
case
yeah.
is called. Another case is called. The moral status of the fetus seems to play a role. The other thing is the possibility of conflicting duties. So the thought is, mom gets into a car accident, driving negligently, and the child is born with a disability, with an injury. The concern is imposing a duty on the mom would create would be too deep of an intrusion, I guess, on her duties to herself, right? Like, so she has discretion to decide how to behave, and she needs to be able to prioritize herself. So I don't know whether the same deep protection of reproductive autonomy might exist in the United
Oh,
States as compared to recognition of the fetus. So that might be a sociological difference between the
well,
jurisdictions.
Scott
Yeah.
discusses Winnipeg, and I think the
And
other
yeah, so
case.
Scott
And I
talks about
didn't
it. Yeah.
get into this because I
Yeah.
didn't want this to
Yeah.
be. I mean, I found Scott's article quite interesting, but I didn't want this
Yeah.
to be a sort of commentary on her. But her view is that, look, if we simply say that the if the pregnant person violates a duty of care that's already well established, like negligent driving, for everyone agrees that there are enforceable standards of care. Um, uh, for that, then it somehow, then you can say, well, by these general conduct standards, that's what she calls it, general conduct standards, you've breached a duty to whomever is in the zone of injury, and that includes the fetus. And the legal
Right.
duty does not sort of encumber the woman anymore. She was already under that duty. If she wasn't pregnant, she'd have the same duty to drive safely. So there would be liability. And Scott defends that exception against charges that it just sort of makes her fortuitously liable to the fetus on those rare occasions, or maybe not so rare occasions, when the injury occurs in a context where there already is a general duty of care. I so I think that's an interesting exception. I don't think it goes far enough. I mean, well, no, I shouldn't say that. As a matter of law, I think it may go far enough. I mean, I think that, the second point is quite a valid point. The other reason why, in fact, Scott endorses that Winnipeg decision is that I believe drivers have to be insured in Canada, so the child would be suing the insurance company by
Yeah.
winning the case against
Yeah.
the child's mom. It would be bringing money into the family to care for the child, so it wouldn't
Right.
be a perverse result. Um, I mean, I think there are lots of good reasons for not actually allowing these. I've tried to focus, although I have slipped more than once, on whether there is an underlying moral duty. And
Right.
I think there could be an underlying moral duty that in most cases was simply unenforceable, either because of its, uh, a discriminatory impact, because of perverse or counterproductive results, or because it was just impossible to apply an objectively recognizable standard of care to the you know to the very personal question whether this individual gave the fetus's or the future child's interests due weight. So I am not arguing for or really against any specific legal restrictions. I'm just trying to explore whether there are, I mean, what I'm resisting is the picture of, well, there's a clear moral duty, but we can't enforce it. I think there, in most cases, is not a clear moral duty. Um, And so there's that much more reason not to enforce it. And, but even when there is a clear moral duty in these rare cases, there may well be good policy reasons not to.
Thanks.
Oh,
Kenneth, you've been
someone,
waiting patiently. And then, and then I'll go back to the chat after you, Ken.
Yeah, so thanks, David. This is a really illuminating discussion, and your analysis is pretty persuasive to me. I'm a torts professor with a little bit of philosophical background, but I've never taught these topics, so it's really a lot of food for thought. But the question I had for you was about the difference, I think your analysis presupposes between duties owed before birth and after birth. And the idea that there isn't really much at all in the way of a moral duty before birth seems in tension to me, to my intuitive reaction to comparable scenarios after birth. So it's hard to do a complete apples to apples comparison, but imagine someone gives birth with the intending to give up the child for adoption, but there's some kind of natural catastrophe and it's impossible to bring the child to the hospital. In fact, somehow the mother and the child are alone and there's no one else around to be able to help. Does she have a duty to breastfeed? Does she have a duty not to drive negligently towards the child? It seems to me there are some significant obligations she would owe to the child that's born, but that in the, spell out the facts however you need to make the child completely reliant on her for everything. Um, it seems that there are more extensive duties there than there would be before birth. And then you can build in whatever you want about, she has religious reasons not to have an abortion or not at all at fault for the pregnancy, etc. So I may be missing something here, but I'm interested
no.
in your thoughts about that.
Well, I didn't actually address the question of whether moral duties owed by an intending parent, gestational duties, are as stringent as duties afterwards. I mean, in some cases, I don't think they are. I mean, I'm drawing from my article, from one of my articles now, but look, a, a it's a fraud issue, but I think most people think that if a pregnant woman has twins and they can't both survive, that it's acceptable. Certainly, I mean, there are disability concerns, say, about killing the less healthy one. But let's just say they're both healthy, but they can't survive because of limited placental oxygen or something. I think most people would agree that it's a pain. It's acceptable, if painful, to randomly pick one to what's it called, fetal thinning or something, a fetal reduction. Yeah, but obviously with born children, if you were in a room, I mean, at least many people would think it would be highly problematic to kill one of the two children if there wasn't enough oxygen for both. I mean, they would say something like, it's better that they all, you know, um, asphyxiate, that they both asphyxiate. Now, both judgments are contestable, but my point is that I don't want to say that whatever duties a pregnant person, an intending mother, owes to the fetus are as strong as the duties that she would owe to a child she had undertaken to, parent. I mean, I think in some ways it cuts both ways. Because she is the only, when she's pregnant, she's the only person who can do so many things that are necessary for the health and well-being of the fetus. That seems to pull in the direction of more duty. On the other hand, the fact that so many things impose on her own domain of, her body, her otherwise self-regarding actions pull in the other direction. So I don't have that's and to me, that's part of the reason why it would be so damn hard to come up with a standard of care. I think my point was just a more modest one, that in intending I think there's a strong case to be made in the intending mother has stronger duties than merely to leave the child with a life worth living. They may be much less stringent than the duties that she would owe once the child is born.
Okay, and I guess, there are independent reasons for saying that there are duties to those who were born as opposed to who haven't been born at all. But I was just, when I thought through the two scenarios, it did seem to me that the very strong sense that there could be pretty extensive duties to a child that's born, even if you never intended to have the child and you intend to give it up for adoption, might carry back to a stronger arguments for saying more extensive duties pre-birth.
That's an interesting idea that you, in fact, I did address that. It is true. Like if there's no one, and now I'm seeing your point more clearly. If there's no one around to adopt a child, and you brought into the world, it does seem like you. And my, and I did in this paper, I have a bibliography here. I did concede that in principle. I said, if you think that if refusing to assume parental responsibilities is going to create a serious risk of a life not worth living, that could be avoided by assuming this isn't a case of a terrible genetic condition. It's where if you assume those responsibilities, the future child will be okay. Then the duties may be greater. But I made the qualified claim that in most post-industrial Western societies, there are even in fairly benighted jurisdictions in the United States, there are safe harbors we can drop off a kid and be reasonably sure that they're not going to have that kind of a horrible life. You can never be sure about any child, but you aren't leaving the child to starve, to be eaten by wolves, or no. So I think that's a very good question. I'm sorry I didn't get around to addressing it at first.
No problem. That's why I suggested that, the quality, it's an emergency, there's the
Yeah.
social conditions are such that it's complete reliance. But no, thank you. I appreciate
you're not the same Ken Simons who went to Michigan Law School, are you?
I am.
You were my
I don't think so. It's 1978.
Well, I stayed for another semester. But nice to
Yeah.
see you again. I've read
Good to
stuff
see you again after all these
so.
years.
Glad we can
Thank you.
facilitate this reunion, actually. So,
Yeah, reunion.
yeah. Um, I did have one quick question too, David, and maybe it does speak to the sort of issues that Barbara's put in the chat too. Um, and I think first on the moral question, and then going to the legal question, I wonder whether there are cases. So I don't know whether duties to self are obligatory or not, or maybe maybe whether perfect or imperfect duties, for example. But I know Daniel Munoz, who's at North Carolina, has been written a lot about duties to self, what we owe to ourselves. And I think a lot of times that,
stuff.
yeah, I think that one of the like ways that you get a conflict between duties to self and lifestyle choices, right? Viewing them as lifestyle choices, that you have discretion on the one hand to decide how to live, a pregnant person does, where sometimes choices made will have a negative impact on the fetus. But there can be, if we accept the view that there are some duties to self that are not a matter of discretion, but that are like genuinely categorical. Those could align with duties owed to the fetus. So if you think that not smoking, you owe it to yourself categorically. It's not up to you whether to smoke or not. Paternalist interventions to prevent smoking are often seen as justified from a public health perspective. Why not view it as the same thing as a matter of individual choice? But also, then that would align with the duty owed to the fetus. In which case, you kind of get an easier way to develop the standard of care. Don't smoke because you owe it to yourself, and that will also. You
That
can see
would
where I'm going.
work for some activities, but it wouldn't work. Would that work for like extreme sports? I mean, someone competing with a really, fetally risky extreme sport that's going to be in the Olympics for the first and possibly only time in the next year. I mean, if you take fetus out of the picture, no one's going to say that's a bad, I mean, that's a bad thing or it's bad for the person. I mean, it might risk injury, but it would be, most people think that kind of athletic endeavor is great, praiseworthy, maybe I
Mhm.
shouldn't say extreme sports because they're crazy, but it seems to me that in some cases you can put the uh ah
That's right.
uh,
There was an Olympian that
look, by the way, since I haven't had a chance to monitor the chat, I hope there's some way that you can preserve the questions I didn't get to so I can respond to them.
yeah, I could save them. I've been trying my best to relay them, but I'll get a transcription. I think I should be able to get a transcription.
Well, that would be
Um,
great.
yeah.
So yeah, I mean, that would certainly work for a lot of the cases, probably for the more familiar cases. But then again, you'd worry really about the idea that here we are legally enforcing. I mean, the pregnant people who can afford to keep their toxic habits indoors and,
Mhm.
indulge their addictions discreetly are going to get away with it, whereas the people living out on the streets are going to be, subject to fairly heavy duty enforcement, even if it is paternalistic. And so, there are concerns about that too. I mean, I really haven't gotten into the policy debate because I don't have anything in particular to say about that, except that I'm sympathetic with the idea that almost anything to do with protecting reproductive health, either prenatally or postnatally, is going to have a highly disparate impact on the
Right.
more disadvantaged people in society.
I think you can. The other example I was going to say was, well, there's lots of sort of nudging that goes on when it comes to public health and nutrition, for example. So when you go to the grocery store, they try to put the most nutritious food at eye level, that sort of thing, and the least at the bottom near your feet. So you gravitate towards it, but so it might be again more permissible to interfere with someone's nutritional choices, which may in turn be better for their standard of care owed to the fetus. But then again, if you're worried about disparate impact, like is for sure,
Oh,
like it's going to
no,
be harder.
no, I mean, Dominic, one of the articles in there that Dominic Wilkinson co-authored and talks is very sensitive to the policy issues, but says, look, nudges do have their place. I mean, I find them exasperating, but on the other hand, I don't feel like my autonomy is infringed by them.
Right.
Just so yes, no. I certainly didn't mean to rule out the idea that even if the recipients of those nudges happen to be worse off in other respects, that's necessarily a fatal objection to making them. But anyway,
I think so. We're out of time. We've been talking for, but
okay. Well, I
thank
would
you very
love
much.
you've got my email. I would love to
Yeah,
communicate with anyone who's any questions about this. I mean, although I am a lawyer, technically, I haven't been kicked out of the bar for not paying dues. I really don't practice law. I'm not very conversant in law, so I would love any legal or philosophical challenges or questions. And you've got my email.
I think one question, and maybe I'll stop the recording now, and I can permit anybody who's got to be elsewhere to leave. So